Connecticut law requires real estate professionals to have a written agency agreement with their clients prior to undertaking to provide real estate services. If you do not have an agency agreement in place and undertake real estate services on behalf of someone else, you will not have E&O coverage from your insurance company. In this section entitled Appointment, it is important to ensure that you list all potential clients here. For example, if both husband and wife will be on title to the deed at closing, they both should be listed as buyers on this form. The broker information should be listed here. Please defer to your in-house rules as to exactly how your broker information should be listed. In this section entitled Property and Area, the agreement addresses the exact property types and areas which the representation agreement covers. By default, the agreement covers all property types listed unless the parties agree otherwise. If it is the intent of the parties to not cover all of these property types, the parties should cross out those that are not selected and initial above the crossout. With respect to the areas of coverage of the agreement, it is important to be specific as possible. For example, do not write Southeastern Connecticut or Northeastern Connecticut, as these are not defined terms. You should use specific towns, counties, or even street names in this area. In this section, the parties agree to the term of the agreement. This is accomplished by filling in the effective date here and the expiration date here. The most recent revision to this form included this next sentence, which provides that if the parties enter a purchase and sales agreement during the term of this buyer representation agreement, and the closing occurs after the expiration date listed on this form, the buyer representation agreement is automatically extended up to the closing date of the property. In addition, there is no need to execute a separate extension of the buyer-broker agreement. This section provides the broker's duties under the terms of the buyer representation agreement. It explains exactly what the broker and agent are obligated to do on behalf of the buyer. Please ensure that you review this section so that you are aware of the exact obligations you are agreeing to undertake on behalf of your buyer. This section is entitled Buyer's Duties. In paragraph 2, the buyer is representing that they are not working with any other broker or agent with respect to properties that are covered by this buyer representation agreement. In paragraph 5, the buyer acknowledges that the broker is being retained solely as a real estate professional. It is important that both parties know the role of the broker in this buyer representation agreement. The broker is not a title searcher, attorney, or home inspector. It is important that you advise your client to seek out other real estate professionals when necessary. Know your role. In this section entitled Other Terms and Conditions, the form provides additional agreements between the parties. In paragraph 3, the buyer is authorizing the broker to deliver certain non-confidential information to the seller or the seller's agent. It is important to remember that confidential information cannot be disclosed. Once information is confidential, it remains confidential during the term of the agreement and after its expiration. Paragraph 8 discusses the potential where the broker may represent both the buyer and seller in a particular purchase and sales transaction. This paragraph addresses these dual or designated agency situations. It is important to discuss these situations with the buyer prior to entering this buyer representation agreement. That way, when you are faced with these issues, it will not be the first time it is discussed with the buyer. Each agency has different rules and regulations regarding the use of dual and designated agency representation. Please consult with your broker so that you may explain these situations to your buyer correctly. Please note that even if you enter a dual agency situation, any confidential information that you obtained from your client up to that point remains confidential. As indicated on the top of page 2, the broker compensation is not fixed by law. It is negotiated between the buyer and broker. Once the parties agree on the broker compensation, that compensation could be entered as either a dollar amount or a percentage in line 1 under professional services fee. As indicated in paragraph 1, the broker earns that fee if the buyer enters into a contract to purchase property during the term of this agreement and all contingencies contained in the purchase and sales agreement are met. Paragraph 2 allows the broker to accept compensation offered by a seller or a seller's listing broker. In that situation, that compensation from the seller or seller's listing broker will be applied towards the professional service fee provided in paragraph 1. If the compensation offered by the seller or seller's listing broker is less than the professional services fee, the buyer remains obligated to pay the difference. In that situation, the buyer may request in their initial offer that the seller pay the difference at closing. As indicated in paragraph 4, if the seller or listing broker offers a professional services fee in excess of the amount indicated in paragraph 1, the broker may accept that higher amount as a professional services fee. In section 6, you should enter an amount of time in the blank space here. If within a certain period of time after the expiration of this agreement, a buyer takes title to any property that was shown to them by the broker during the term of this agreement, and the buyer later closes on that property, the buyer will be responsible to pay the broker a professional services fee. However, if the buyer signs an exclusive right to represent buyer agreement with another broker after the expiration of this agreement, broker 1 will not be entitled to any compensation. This section illustrates the importance of getting extensions to your buyer-broker agreement. This form was prepared for general use by the members of ECAR. If your particular transaction includes terms and conditions that are not contained in this agreement, you may add them here under additional provisions. However, please have those provisions reviewed by your broker or legal counsel before executing the document with your buyer. Connecticut law allows brokers to file a broker's lien in certain situations. If you are considering filing a broker's lien, please consult with your legal counsel. There are many technical standards that must be met in order to perfect a broker's lien. As you learned in your Principles and Practice course and many continuing education courses, both state and federal law prohibits discrimination in commercial and residential real estate transactions. You must follow all lawful instructions of your clients. However, if your client's instructions are to violate fair housing regulations, you are not obligated to follow those instructions. If you find yourself in a situation where you have questions about how to handle a fair housing situation, please consult with your broker or legal counsel. The parties may use an electronic record, whether fax or by email, to make and keep this agreement. In order to do so, the parties should enter their fax number and or email addresses in this section. In the signature section of the form, it is important to remember to have all parties sign the form. Any buyer listed on page 1 should sign here on page 2. Please enter their street addresses, telephone numbers, and remember to date the form. If you have any questions or comments regarding this or any other form, please do not hesitate to contact me or any other affiliate attorney for answers.